Hello, this is Matt on the Moon Lambo channel. Ya done messed up, son. Look at this, Nexo. Nexo has been sued. We're talking about a class action lawsuit here because they halted XRP payments as a result of the SEC going after Ripple. And there's an individual claiming he lost over $250,000 in XRP. So plenty of legal stuff to talk about in this latest Moon Lambo hot jam. Along with a few comments from attorney Jeremy Hogan, who has become a rock star within the XRP community. I'm sure many of you, if not the vast majority of you at this point, are well familiar with who he is. And then there was also this article from Crypto News Flash, Ripple vs. SEC. Next big event is on April 6th. Motions to seal just a sideshow. But I do want to be clear at the outset that I don't have any sort of legal or financial background. I am not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast who makes YouTube videos all up on the YouTubes, and it's a fun hobby. It's about Ripple typically and XRP and crypto-related stories, but it is all that it is, just a very fun hobby. And I appreciate the support. You guys are pretty gosh darn awesome. The words are hard right now, apparently. All right, so let's go ahead and jump right into this. Man, what a train wreck the SEC has created here. A cryptocurrency lender, Nexo, has been hit with a class action lawsuit over its unlawful suspension of XRP payments in late December that has caused $5 million in damages. A plaintiff, man, should I even try this name? If you're looking at the screen, you're probably saying, no, Moon Lambo, don't even try it. Plaintiff June, I'm going to call you John. I don't know how to say your name. Your name is foreign to me, which in and of itself is not a problem, other than I don't know how to say it. So I'm just going to call you John, because I can say John. So anyway, Plaintiff John filed the suit in the Northern District of California on behalf of other similarly situated users earlier this month. After the U.S. Securities and Exchange Commission sued blockchain company Ripple, Nexo rushed to suspend the ability to repay loans with the affiliated XRP cryptocurrency or using it as collateral. It didn't provide its users with notice of the suspension. And so this is interesting because I was thinking about this. I haven't really talked about it on the channel. It's just one of those little passing thoughts that entered Moon Lambo's brain. But when there was word that Coinbase and Bitstamp, pick your cryptocurrency exchange, when they decided and publicly announced that they were going to halt XRP trading, it was not immediate. They picked a date that was, whether it was a week or 2 or 3 out, whatever it ended up being for the cryptocurrency exchange in question, it was not immediate. They gave people an opportunity to liquidate their own positions or move, whatever they wanted to do. And now I'm thinking that this is me kind of wondering here, because look, these exchanges, they have legal teams that they have hired to tell them what's the best way to move forward to potentially either not get sued, or if we get sued, lose less money than if we do something different than this. That's basically what's going on here. And so I started thinking, okay, well, clearly they were advised by their legal teams to halt the trading of XRP because that was the least risky approach. I get that. I don't blame them for taking that move. I know some of you do, and that's fine. We can disagree. I blame the SEC personally. And so I was sitting there thinking, though, they did go ahead and leave some time for XRP holders to act. And so they must have known, wouldn't you think, that if they didn't provide notice, there would be an opportunity for this type of action, for people to come after and saying, hey, look, I couldn't move my XRP, this or that, it caused me harm, and then there could have been lawsuits. There was real risk to that, I think, which is illustrated here because Nexo's getting hit. Where on the flip side, had they gone ahead and just halted XRP right out of the blue with no additional notice, then they would have been more compliant from their point of view. I'm not saying this is just, but from their point of view, they would have been more safe from the SEC. So it looks to me like they're kind of figuring, okay, what's going to be worse? If our customers sue us, or if the SEC comes after us because we did not immediately halt the trading of XRP? And it looks like they placed their bet, and Coinbase, along with the others, said, okay, probably safer to go ahead and just give some time for our customers to do whatever they want with their XRP, whether they want to sell it are the crazy ones want to buy more, right? The crazy ones. And then are moving off the platform, whatever. With Nexo, though, not really a heads up here. And so the piece continues. Hundreds of affected customers were locked out of maintaining their loan-to-value, or LTV for short, ratios, since they couldn't sell their tokens, which triggered a string of liquidations. And here's a quote. Nexo thus effectively prohibited these customers from maintaining their LTV ratios, and then punished them for not maintaining their LTV ratios. And then the piece continues. John claims that he lost $269,300 worth of XRP tokens that were posted as collateral. Whew. Oh man, that's a rough go. Can you imagine just getting liquidated because of something like this? And it all begins with the SEC. Now, I do think it's pretty crummy if this is all accurate. I'm assuming that it is here. That Nexo gave no notice of this, and there was no time to act. That sounds pretty awful on the surface here. I don't know how you justify something like that. Not logically. Like, you can come up with justifications for anything, but I'm just saying logically. So anyway, the lawsuit says that Nexo was not entitled to liquidate the collateral of customers. The plaintiff counters the company's public statement published on December 30th, which purported it owned the XRP tokens held as collateral. And here's a quote. If Nexo were to acquire the ownership of the crypto assets that Nexo customers post as collateral, this would be an extremely unfair result that unreasonably favors Nexo over its customers, and that resulted from the Nexo customers' lack of reasonable choice or negotiating power over the terms and conditions that Nexo imposes on customers without any negotiation. And so, not surprisingly, customers want to recover their funds. Nexo customers are seeking to recover the value of their XRP when the lender suspended its use. And here's another quote. Nexo customers are also entitled to the value of the digital assets taken from their savings wallets and the value of the digital assets or cash that they transferred to their credit line wallets to maintain their LTV ratios during the suspension of customer use of XRP, because any obligation to maintain those ratios had been excused. And so then they wrap up the article writing, John is asking the court to award him and other affected users damages in amount to be determined at trial. So, and they can be awarded, and they cite here too, any amount that's deemed proper by the court is what could be awarded. So it could be millions and millions and millions and millions of dollars, which could have been avoided if they had provided some notice to their customers. I'm always willing to hear both sides of the story and then be persuaded. So I mean, having not heard a sufficient argument from Nexo, I'm not going to say I have an absolutely firm stance on this, but I will say, like, that's got to be a tough position to defend if you're Nexo, don't you think? Like, you wrecked people's financial lives. Like, that's what it looks like. I'm willing to be persuaded, but that's certainly what it looks like. Here's a few tweets from attorney Jeremy Hogan. He writes, I've been busy the last 2 weeks with a trademark violation case. We moved for a preliminary injunction, which was granted yesterday. I'm very happy about that. A preliminary injunction asks the court to stop a party from breaking the law right away. It took us 2 months to win. And so right there, he's talking about a real-world case for him, and he highlighted a couple documents from his particular instance, and he redacted some of the information, which of course makes sense. I'm not going to pull it up, it doesn't matter, but I just wanted to be clear again. He is talking about his case, but then he transitions to the fun comparison having to do with what's going on with XRP. And so he wrote, which makes me wonder if the SEC truly believes Ripple is violating the law. Why didn't it move for a preliminary injunction? They certainly have done so in other cases. The standard is one of substantial likelihood of success. Perhaps the SEC doesn't have the facts and believes it will procure the facts through discovery, or perhaps it's worried about the substantial nature of the bond and damages it would have to pay if it lost. If any, the failure to file a preliminary injunction is not a sign of SEC strength. And I talked about this in a video literally yesterday. This idea of, if the SEC is so certain of their case, as they're at least pretending to be, why are they not filing an injunction to make it so that Ripple can't sell any XRP? They didn't do that. Well, like Jeremy Hogan said here, either they think they're missing facts that will make it so that that type of action would have made sense, or they're not so confident about their case. I think that they know that they've got weak hands here because their positions. I would not envy being the SEC lawyers here, because you can clearly tell, even not having some sort of legal background, and I don't, just seeing the hypocrisy, the degree to which they're illogical, like they're just fighting for any legal argument they can like drum up in their minds and just seeing what sticks. That's absolutely what it looks like to me. It's not rational. So good luck, bitches. I'm just saying. And then here's another tweet from Jeremy Hogan. In the SEC versus Ripple case, there has been a lot of activity. Re, the motions to seal documents and some other minor discovery issues. Don't lose sight of the forest for the trees. These motions are not vital to the case. The next big thing to look at is the hearing on April 6th, so just a couple days from now. Which leads us to this piece from Crypto Newsflash on that topic. In Ripple's legal dispute against the U.S. Securities and Exchange Commission, things have been no less quiet in recent days than the weeks before. However, both parties are currently arguing about an issue that will probably not really be decisive for the outcome of the case, as attorney Jeremy Hogan commented via Twitter. After Magistrate Judge Sarah Netburn granted Ripple's motion to temporarily seal 4 documents on March 31st, she ordered Ripple and the SEC to agree on redactions by April 2nd. As the latest court documents reveal, both parties managed to agree on redactions to 2 email communications. Specifically, one email was between Ripple CEO Brad Garlinghouse and RippleWorks, the company's nonprofit VC arm. The second email communication was between anonymous parties and concerns the public perception of XRP and the control of Ripple. On the other side, Ripple's legal team explained that no agreement was reached on the 2 other documents. These concerned personal financial information of Ripple executive Chris Larsen on the one hand, and sensitive information regarding the initial distribution of XRP, including information gleaned from discussions with counsel on the other. And so, the next big thing, it's the April 6th hearing. So check this out. According to Jeremy Hogan, he summed up that the documents are merely a sideshow, which I just highlighted. And then they actually go on to cite that actual tweet, which I just shared with you. And as Hogan further elicited, it is difficult to comment on the arguments about the motions to seal the Ripple documents because the public does not know what is in the documents. But what I can say for sure is that Ripple does not want the public to see them, he said. One can only speculate about the motivation behind this trench warfare. And here's a quote from Hogan. Is the fighting becoming personal for the SEC, or does the SEC believe there are PR issues at play here? This probably won't affect the case directly, but a letter from a securities lawyer to Ripple saying it will likely get sued and subject employees and business partners to litigation is not a good PR for Ripple, even if it was 9 years ago. Which I think is a fair point to bring up. Meanwhile, the lawyer again stated via Twitter that the SEC itself seems unsure whether it has enough evidence to go against Ripple. And so, which goes back to what I just was talking about before as far as this idea, like, why didn't they file that preliminary injunction? Well, I'm not convinced that they thought, or think even now, that there's some sort of serious winning hand here, other than collecting some fees if Ripple wants to settle, or maybe they actually can legally make that case. But as far as the most important stuff that would prevent Ripple from selling their XRP or XRP being traded forever in the United States, I can't imagine that stuff happening. But we'll just continue on the roller coaster ride. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.